This presentation covers Chapter 3, and it is only covering the section of Chapter 3 of the Sloan book, Defining a Research Question. The next presentation will go further into Chapter 3 in terms of generating research terms. These are the areas that we're going to cover. The presentation will cover the points of what is a research question, what types of research questions are there, what is a good research question. We'll cover a case scenario in order to apply this topic. The next topic is identifying the legal doctrines of our case scenario, stating the legal issue, and then finally the legal issue you will research to find information and rules of law for this module. What is a research question? Lawyers conduct legal research to obtain information and rules of law to solve problems for clients. In the very broadest sense, the issue is a question, the legal question raised by the dispute. It occurs whenever there is a disagreement or uncertainty about whether or how a rule of law applies to a client's facts. The author of our textbook, Amy Sloan, does not use the term issue, but the term is often used in legal research and analysis. Identifying the issue, a task which is commonly referred to as spotting the issue, is the first step of the legal analysis process. As such, successful research requires that you ask the right questions in order to get the information and rules of law that you need. Thus, you have to ask the right question or questions. The issue determines which direction the research is going to take. It's like selecting a road to take when you reach a fork in the road. If you choose the wrong road, you're going to waste a lot of time before you get to your destination. Or you could get lost and never get where you were going in the first place. So not only identifying the issue is the most important step in the analytical process, but it's also the most difficult sometimes. When you ask a legal professional, for example, how to spot an issue, the response is often, "I just know," or after a while, it becomes intuitive. This does not help the beginner very much. Although no simple rule or magic formula exists, there are techniques and steps that are helpful and useful when identifying the issue in a client's fact situation. What types of research questions are there? Well, in classes you'll often find that defining a research issue or question will take a lot of experience. But early in your coursework, you'll often research questions that are, predefined by your professor. For example, what must a plaintiff show to establish the tort of battery in Florida? When given a research question, answer the specific research question given. And in this class, we're going to use predefined research questions in some cases, so please be alert to that. The important thing is that it takes a lot of focus in and of itself, just staying with your research question, even if it's predefined, because your research can take you to new ideas. This is very natural. With experience, however, you'll learn to define a research question yourself. And in this particular course, as I've already noted, it's not really intended to bring you to this learning objective of defining a research question. You'll do that in PLA 1104, and you may have done it in some other courses as well. What we want you to do successfully is use electronic research sources to find the law. So I'm going to, as I pointed out, predefine the research questions, or if you hear the term issue, it's the same thing. So for now, there are three broad categories of issues. One would be a question of which law applies. The other would be a question of how a law applies. And then the third is a question of whether a law applies at all. What is a good research question? Sometimes it's called, as I pointed out, the legal issue. Although your research questions in this course will be predefined, it's important to understand what this good research question is. To form a good research question, you need to blend together the legal question with the context of the facts of the situation. Why is this? Because if you're going to find the rules of law that apply, the context of the problem cannot be ignored. Recall in an earlier presentation I gave in this course, I told you about the student who did research in the statutes for a landlord-tenant claim and returned with the results that applied to the Uniform Commercial Code. We simply cannot apply legal rules that don't apply to the facts, and vice versa. One method that works well for students in the paralegal research courses is to do some initial research first, often from secondary sources, in order to locate primary sources. Remember that secondary sources are commentary about the law. We discussed that in the first module. We'll cover more on that process of researching secondary law in very soon. However, don't underestimate the importance of this of the task of defining a research question. First, the research question promotes efficient and effective research. A search and destroy method of research is possible, but it usually takes longer, and more importantly, they're not always correct. It is possible to, serendipitously find the law that applies to your case without first defining a research question. However, it's likely to take longer without a research question predefined. So let's look at our case scenario on the next slide and talk about a predefined legal question and how we might have reached it. This is a case scenario. Actually, it's from the textbook for this course, the textbook by Sloan. You can read it on page 22, but note that I've changed in this scenario for this class that the client lives in Florida instead of North Carolina. So your client lives in Florida. He lives in a duplex with a front porch that extends across the entire front of the house. Your client's side of the porch is separated from his neighbor's side by a railing. The neighbor likes to smoke cigars on her own front porch, but the smoke travels to the client's front porch. The client told his neighbor that he finds the smell of the smoke intolerable. The neighbor had previously promised not to smoke on her front porch, but regularly broke her promise. And this is to the client's great consternation. One day, while the neighbor was smoking on her porch, the client berated her for breaking her promise. The neighbor, without saying a word, leaned over the railing that separated the two porches, blew cigar smoke into the client's face, and sat back down on her porch to finish the cigar. The client is upset about this interaction and wants to know whether he can recover damages from his neighbor. Now let's examine the case scenario to decide what legal doctrines might be applicable to this case. Because remember, we're trying to form an issue which is a blending of the legal doctrine and the facts of the case. First, we look at the case facts to determine the applicable laws. The neighbor leaned over the railing. Which legal theories apply when one person enters the property of another person? Could this be trespass? Does trespass occur when an individual leans over a porch railing? Next, the neighbor made a promise she didn't keep. Which legal theories apply when one person breaks a promise to another person? Could this be breach of contract? Is a contract breached when someone promises not to smoke on their front porch? Next, the neighbor blew smoke in the client's face. Which legal theories apply when one person purposely offends another person by blowing smoke in his face? Could this be a tort, possibly battery? Does battery occur when someone intentionally blows smoke in another person's face? You may or may not be skilled at identifying these doctrines and theories. Your skill will depend on your experiences. For example, the law courses you've taken, they may have addressed some of these doctrines in courses, but if not, you would only know of the doctrines of trespass, breach of contract, tort as a battery as a tort because of experience of another kind, maybe outside of school, maybe you have other education. But what if you don't know the doctrines that the situation presents? You could develop research questions using just the facts of the situation, covering the conduct of the parties, the mental states of the parties, the injury suffered by the complaining party. You could develop research questions by considering the parties in terms of their relationship. This helps define the duties and obligations of the parties. For example, a landlord-tenant obligation and duties, neighboring landowners, parent and child, employer-employee, husband and wife, parent and child. Also, you need to consider what legal doctrines a situation presents by evaluating the geography and the type of location. You could develop research questions by considering the place where the conduct at issue occurred. And this question is vital in all case scenarios, because you have to examine the case according to the jurisdiction. That's the geographical location, so that you know what rules are going to be binding / mandatory versus non-binding or persuasive. Remember that from one of the earlier presentations in the first module. The geography of the case scenario also helps you determine through your research whether the claim is even available in the state where the conduct at issue occurred. Some states, through case law and or legislation, bar some types of claims. Also, the type of location is significant because it can affect if the rules apply at all. For example, the single-family home rental versus a merchant's business place, as I've discussed before, can seriously affect your decisions in determining which rules apply to the case. So let's look next at how we blend the legal doctrines with the facts and formulate a research question. All right, so the author of the book these are on one of the pages in Chapter 3. The author of the book has stated the legal questions for this case scenario. As noted by the author, the client does not come to the attorney with predefined legal questions. It's our job and the attorneys to identify the legal questions when given the facts of the case. These emerge, obviously, from the client interview. So the first one, trespass. In blending together the legal doctrines, the legal doctrine of trespass with the facts, we simply ask the legal question: did the neighbor trespass on the client's land by leaning over the porch railing? The second example of legal question is breach of contract. Did the neighbor breach a contract by breaking her promise? The third legal question concerns the legal doctrine of tort in the form of a battery. The legal question is, did the neighbor commit the tort of battery by purposely blowing smoke in the client's face? So next, let's look at the case scenario that we're going to apply. One of these three, and that's the tort battery claim. We're going to apply that in our assignment coming up in this module. For this lesson, we're going to use the tort battery case scenario. The next presentation explains how to generate search terms and describe the information and rules of law you'll seek in doing your research. All right, so that's the next presentation. To conclude, we've answered the questions. What is a research question? What types of research questions are there? And what is a good research question? We looked at a case scenario and saw how the author identified the legal doctrines of our case scenario and stated the legal issue. She stated 3 of them. And now we also know that the legal issue that we're going to research is the one on tort and battery. The next slide is the last slide, and it has the references for this presentation. Thank you. Please look for the next presentation on the same chapter, and the name of that presentation is Generating Search Terms for Research.